Which cryptocurrency is being attacked by the SEC after XRP? How long will crypto holders believe in Ripple? How much will XRP cost in mid-2020? 3. We will answer all these questions. A district of Massachusetts judge granted the SEC's move for summary judgment and denied the defendant's cross-motion for summary judgment in the lawsuit against Commonwealth Equity Services, LCLC, on April 7, 2020. 3. The agency claims that this ruling proves the SEC's allegations against Ripple for violations of federal securities laws, including substantial misrepresentations and omissions of conflicts of interest. The SEC brought suit against Commonwealth and its CEO, John Roney, in 2019. Success for the SEC in court. Most notably, the court did not buy the defendant's procedural argument that he had not received sufficient notice from the SEC of the disclosure duties asserted in the complaint. The SEC contends that, as in the Commonwealth case, Ripple's fair notice claim is irrelevant here. Commonwealth, like Ripple, contended that a 50-year-old Supreme Court rule addressing disclosure responsibilities was inadequate to warrant fair notice. So the SEC makes the connection between the two companies. The court, however, sided with the SEC, holding that enough notice had been provided. The SEC argues, first, that Howey and its progeny presented defendants with adequate fair notice to defeat their constitutional argument, since they established that lengthy Supreme Court law may offer fair notice. The SEC argues that the Commonwealth decision supports its petition for summary judgment and the rejection of Ripple's reasonable notice position. The XRP legal community does not think the letter makes any compelling points. According to yesterday's Bitcoinist post, defense attorney Jeremy Hogan considers the underlying technological question to be central to the case. If Judge Torres is familiar with blockchain and decentralization, he may consider a Ripple win as plausible. When asked about the recent SEC letter, Australian attorney Bill Morgan responded dismissively, saying, "There's no comparison. If you're worried about the SEC bringing this case to Judge Torres' attention because you believe the facts are similar to the case in which an investment advisor failed to make all necessary disclosure of potential conflicts of interest from which it benefited to retail investor clients to whom it owed fiduciary duties and whose funds it managed, then you're not alone." The founder of Hodl Law, Fred Rispoli, said that the letter is not super on point and may cause the judgment to be postponed even more. Judge Torres has been quite fair throughout this matter, always allowing the other side time to file a response to any extra briefs that have been filed. Rispoli says, Ripple could file a response to this in under 2 hours, but he anticipates a delay. After the conclusion of the Ripple v. SEC lawsuit, XRP is expected to be one of the best performing assets. Ben Armstrong, well known by his stage name Bitboy, persists in promoting this version of events. The well-known crypto influencer recently said that the resolution of the lawsuit will provide a windfall to XRP holders who had held out. On Wednesday, Bitboy turned to Twitter to air his thoughts, using a famous remark often ascribed to philosopher Seneca. He said that when the Ripple VC case is resolved, it will be the closing of one era and the beginning of another. The Ripple case may be resolved at any time. When one thing finishes, another one begins. The new thing is that if you stay with XRP and the Thuxerp army, you can make a lot of money. It's time to start eating your rations. According to him, when the protracted legal actions with the SEC are through, the new chapter will begin, and XRP investors will begin to generate enormous profit. He urged the XRP army to keep going, saying that the payoff for their efforts was just around the corner. In addition, Bitboy said he believes the ongoing legal battle between Ripple and the SEC will soon come to a close. Since the famous crypto influencer had earlier projected that the litigation will finish in September 2021, the XRP community is treating this remark with a grain of salt. Bitboy said openly that he was wrong when he predicted September 2021. Although the trial schedule is likely to wrap up soon, he stressed that his recent comments were not idle speculation, but rather based on hard data. As was previously reported, Attorney John Deaton anticipated a decision by May 6. It's great that people are criticizing me because I think the Ripple case will be resolved shortly. I thought it will all be over by September of 2020. 1. I've never been more specific than that date. No such thing occurred. The XRP lawsuit will soon come to a close. That's not a forecast. Dogebags, the trial period has come to an end. A new development in the SEC's action against Ripple, a blockchain company, has the potential to dramatically affect the ultimate result as the cryptocurrency world awaits the summary judgment. The SEC's expert has stated that changes in the values of Bitcoin and Ethereum have been responsible for up to 90s of swings in the price of XRP since mid-2018, as reported by lawyer Bill Morgan in a tweet on April 7. He hypothesized that if the SEC's premise about its expert's knowledge is correct, it may mean that Ripple is allowing the value of XRP to be affected by the swings in the value of Bitcoin and Ethereum. Therefore, the SEC tries to prove the claim by providing proof that XRP's value is affected by Ripple's price announcements. Morgan's point is bolstered by the fact that the value of Bitcoin affects the value of most cryptocurrencies. Morgan also noted that the view that XRP is a security and that Ripple's large XRP holdings imply centralization of the XRP ledger remains. Importantly, the SEC is suing Ripple for offering XRP coins for sale without first registering them as securities. Ripple is seeking to defend itself by having the regulator's remarks from a lecture he gave in which he referred to Bitcoin and Ethereum as securities unsealed. The SEC claims that investors are counting on Ripple's legal efforts to succeed, and Morgan agrees. The lawyer further clarified that investors do not expect Ripple's commercial activities to earn profits from XRP, but rather on the company's legal efforts to emerge triumphant in the SEC litigation. Contrary to what the SEC believes, Ripple's legal efforts defeating the SEC's lawsuit, should it be successful, mean that investors were right to put faith in the company? Jeremy Hogan, another advocate of XRP, used Morgan's comments to forecast a surprising verdict in the case. Since even the SEC acknowledges that Ripple's activities after mid-2018 had no effect on the token's value, Hogan hypothesized that if the presiding judge opted to split the baby, she might determine that XRP sales after mid-2018 were not securities. Even the SEC admits that Ripple's activities have had essentially no influence on XRP's price since mid-2018. Thus, the judge, in the Ripple case, if she wanted to split the baby, that's a dreadful expression, isn't it? May decide that sales of XRP since then were not securities. Hogan said that the verdict might have far-reaching consequences, including the possibility that Ripple would have to pay a fee just to keep doing business as usual. As the sole cryptocurrency with a well-defined legal position, Hogan pointed out that XRP may have an impact on how other digital assets are treated by exchanges. Meanwhile, the timing of the summary judgment remains a matter of conjecture. The first estimated timing for the lawsuit verdict was the first quarter of 2023, according to some legal experts. The overall value of XRP and the cryptocurrency market might be affected by the verdict in this case. XRP is up around 1 on the week, trading at 51 cents right now.